Live.
All right, we are here Thursday morning, the 23rd, sorry. And so we have a busy morning, just be prepared for a very long day on the floor. Today is yesterday was kind of spring training for the length of the floor. The clerk of the House sent us an invite that said we should be here till 9 o'clock, and that's not rare during this week of crossover week with so many bills and so many big bills like ours, which will be on the floor today. This morning, we're going to hear testimony for the next 45 minutes to an hour on H-184, which we had an introduction to and a walkthrough, such as it was yesterday. And then we're going to hear about amendments to H-66, which is the family leave bill. We'll hear what the House Committee on Appropriations is proposing. And then after that, we will hear about an amendment that is on the calendar from Representative Toof and Beck. And Damien will be here to walk us through that amendment as well. That should take us right up to lunchtime, and then we are on the floor all afternoon. And the same kind of rule that we had yesterday. If anything comes up with respect to any of the bills that we're doing, which would be H-66 or 213. No, 213 is the mobile home bill. That's on the floor, I think, today. Or maybe it's not. I don't know. I haven't checked the calendar. It may not be on the floor today. At any rate, if there's amendments that we have to respond to in the moment, then we'll come back here during the course of the afternoon. But right now, we just have we have appropriations work and this amendment to H-66 from Representative Toof and Beck. With that, any questions before we get started? You okay?
Yep.
Okay. So we're going to start today with David Englander, who is a senior policy and legal advisor to the Department of Health. And David, thank you for coming in today. What we learned about this situation is that it started in 2018, 2019. But here we are.
Here we are. So good morning. My name is David Englander. I'm the Senior Policy and Legal Advisor to the Department of Health. So for the department, so I'll give a little bit of background. Actually, before I give just a preface, which is to say that that Mr. Bierke has filed an action against the department on this subject matter, and I'm sure we're both going to. You'll file an appeal in the decision of the department to deny your request for rulemaking. So I'm going to respect that boundary. No, I'm sorry. He has a perfect right. That wasn't a criticism. I was just establishing where we are passionate.
It's not an action.
It's an appeal.
In the APA.
Well, it's not. We can talk about this later. It's not within the APA because the APA is concluded. We can talk about that at some other point. Two lawyers. What a pain. Worst.
No, David was here yesterday. He heard us.
Okay. So for the Department of Health. So good morning.
On that note.
And on that auspicious note.
Thank you. So with that, so what does that mean to you?
So what it means is there are questions that I might be circumspect about answering. And I'll just be very upfront about that if I feel like it potentially affects the matter that's currently being litigated. For the Department of Health, this starts long before 2018. This was something the department was considering in the mid-teens, I would say starting about 2015. It became clear that the EPA did not have the resources to undertake this extraordinarily protective program concerning the lead remediation and removal. They simply do not have the resources to properly communicate with all folks who might be affected, whether they be landlords or child carers or private persons who want to do lead remediation in their homes. And we're talking about lead remediation, we're talking about, as you discussed briefly yesterday, we're talking about 1970, pre-1978 housing. All pre-1978 housing is presumed to have lead paint in it because until 1978, lead paint was allowed to be sold commercially. It is no longer allowed to be sold. The Department of Health, you should know, just kind of broadly speaking, we have a safe homes program whereby if there are elevated blood levels in a child, the department goes out and on a voluntary basis, we do investigations to determine the cause of lead poisoning or elevated blood levels. All 1 and 2 year olds, where I should have started, all 1 and 2 year olds are required to be tested for lead. So it was the department's perspective that there was an issue because we had across the state elevated blood levels within children. So we looked at what the causes and drivers might be and how the department might be of systemic assistance to the Vermonters. And in that case, we then fell upon the notion that we would adopt the RPM program from EPA. That process, sorry.
And so just to even roll back one revolution, lead in paint, lead in gas.
Yes.
Was made illegal in the 70s. What are the ramifications of lead paint for, I mean, I've been exposed to PSA, to public service announcements about what lead paint can do, but if you could just give us a quick primer on what lead paint and why this was important.
Yeah, I was coming to that, but absolutely, I'm happy to do that right now. The stakes couldn't be higher in case of lead paint. There's a child who's exposed to lead paint will have there'll be impacts on the child's nervous system. There'll be permanent reductions in IQ. When we talk about lead paint, exposure to lead paint, we talk about something that is completely that is totally preventable, but non-reversible. So when we talk about children who've been exposed to lead in particular, we're talking about the lifetime impacts on that person, the person's education, the interactions with the criminal justice system. I had a medieval history professor who believed that the Roman Empire fell because of lead pipes in Rome. So these are extraordinary implications for the person, but also for the state.
So a child can get it by the classic was by eating paint chips.
That's right. In fact, exactly right. The problem with one of the many problems with lead is that it is sweet to the taste. And so frequently what happens is there's a child who we discovered have an elevated blood level, and we go into the home and we find that it is typically, and Mr. Chair, it sounds like you know this, it's in the window well. And there's peeling paint in the window well, and the child is standing and looking outside and is eating the sweet paint. So this is, and those damages are irreversible. So this is a monumental problem, both across the state and across Vermont. So this is all what you're saying. This is all the impotence for the Department of Health saying, let's adopt these rules. Let's take on this program. Let us deploy the resources that are necessary to actually assist Vermonters. That's true for people who are in rental housing, but it's also provide assistance to landlords. Something that we talked about during the passage of the bill in 2017 is that we wanted any person to be able to call of somebody in Vermont and get answers to their questions. If you've ever tried to call EPA and get an answer, it is extraordinarily difficult. If you call the Vermont Department of Health, you're going to get a human being within 30 seconds, and she's going to answer your questions. I say she because today it's Meg McCarthy, who would be here, who's the true expert in this subject matter, but she is taking some well-deserved time off. But you get her immediately, and I think actually, Mr. Beer, you've spoken with Meg, I believe.
Yeah, she called me once.
Yeah. So we want to be able to provide not only the protection necessary, but also the customer service necessary to actually do this well. So at this point, I'm going to need assistance.
Yep.
Tell me, you tell me what to do and I'll do
So
it.
go to your Zoom.
Okay, there we
And
are.
then, does he have, okay. So you're going to, do you mind if I?
No, go ahead.
I promise I wash my hands. And then just whatever screen that you want. It's probably,
So I want, there's a Word document.
So I would hit. So you're gonna open your system preferences
Mr. Chair, I apologize.
and then just hit on Zoom. And then password, can't help you there.
Don't look at my password.
And then,
Now it's telling me to leave meeting. No.
okay, and then, so you'll have to hit share screen at the very bottom, it's green. There,
Ah,
perfect, and then you already have,
yes.
there you go. And then just hit share. Oh, there you go, perfect. You're all set?
Wow, thank you so much.
Of course.
Senator Bartley does not get an extra paycheck for being here.
An extra 10. So just to briefly go through the timeline, I'll try to be brief. So the act was signed, the original act was signed in 2017. Before I begin, I've been doing rulemaking for about 20 years, and I think the vice chair has probably seen me a few too many times in front of Elcar. I'm not sure there's somebody who's done more rulemaking in Vermont than I have. As the former Fish and Wildlife General Counsel, you tend to do sometimes 10 and 20 rules a year. So I've never been involved in a rulemaking that was this complicated and this interactive with the regulated community. So the rule was, the law was signed in 2017, and we started doing stakeholder input. We did, as we say, the survey that was done, talking to childcare, rental property owners, led industry representatives. That happened in the fall of 2017. In early 2018, as you can see, I don't want to read everything that's on the screen, but we invited all these folks into the room, literally and figuratively, to talk about what was coming. At this point, we did not have a rule draft. We were just talking about this is what's coming. We need to hear from you to understand the landscape. The thing about agencies, of course, is we don't know things. We don't know what we don't know. So the whole intention was to have as many people in the room as we could. I should also note that many of these people were involved in the passage of the law itself. A lot of these folks came and they testified, and there was, this is my perception, there was universal support for the act, because for the reasons I've articulated, not only the importance of protecting Vermonters, but also that this would be a homegrown program. So we had stakeholder meetings in May, and then we began to draft the rule in August of 2018. The interactions with EPA were often complicated, often contentious. We went back and forth with drafts many times. Sometimes we would get an opinion from EPA, and that person would leave their post, and a few months later, somebody would come back and they would have a different opinion. And so we would be shifting and trying to be responsive to their needs, as well as the needs of the regulated community. You can see that in February 19, we actually had a kickoff meeting. This was with stakeholders. At that point, we had word from EPA that they wanted some changes, which Katie mentioned very briefly. And then we advocated for those changes, which also, my perception is that there was universal support. And I don't want to read through all of this, but essentially, we had, in January of 2020, we sent the draft rule to stakeholders. This is all pre-rulemaking. So 4 major steps. So typically what happens in rules is do people already know how rulemaking works, and we useful to me to do 30 seconds?
He knows a lot more than anybody else does, but generally speaking, if you could just give us a 3-minute, I'm sorry, I know I'm asking a lot for a 3-minute.
I have a CLE that I do. It takes an hour. It's fantastic. At least I have a good time. So when an agency receives, the General Assembly gives to the agency enabling legislation. Ideally, the General Assembly says, Department of Health, please enact rules that do X and Y. At that point, any agency begins what's called the Administrative Procedures Act. It's 3 VSA Chapter 25. And that sets forth a stepwise process whereby there is a series of filings. First, within the administration itself, which is called the Interagency Committee on Administrative Rules. This is where we meet with our colleagues, other general counsels and policymakers, and make sure that there's consistency within an administration. It is then publicized the rule is published. There's generally speaking a public meeting or sometimes multiple public meetings. At any point, anybody can send in any kind of comment. It can be written, it can be verbal. All the comments that are received by any agency must then be responded to in writing. We're adopting your recommendation, we're rejecting your recommendation, and here's why. All that information, all the changes made to the rule following public comment are then brought before the Legislative Committee on Legislative Rules, on which is a joint committee of Senate and House members, who then sit and decide whether or not the rule matches legislative intent. They also determine whether or not the plan to maximize public interaction has been actually undertaken by the agency as promised in the rulemaking forms.
Just in case, add to that to say that the role of LCAR is not to review policy. It's to review, primarily, does the rule reflect legislative intent, and then was correct procedure followed? And it's rare that LCAR will say this rule as proposed conflicts with legislative intent as indicated here, and that's another story, but primarily it's a review of consistency with legislative intent and procedure rather than policy setting.
What if they don't do any of those things?
If
For
LCAR
example, if they don't respond to public comment to the proposed rule in writing,
I would.
what if they don't do that?
I would think that LCAR would object to the rule, and if an agency can file an adopted rule or the objection of LCAR, but then if it is a challenge in court, it doesn't have the presumption of legality.
Okay, thank you.
I've never heard of an agency not doing that, although Mr. Vice Chair, you may have seen it.
We had one where they adopted so there wouldn't be a void in statute, and then revised shortly thereafter, adopted over objections. But that was to create a void, and with the understanding that it would be revised shortly.
And this is for normal rulemaking. This is not for emergency rulemaking.
Right.
That's right.
Right, so that's a whole other world.
A whole other world we can talk about tomorrow.
That's another half an hour of CLA, right? So, but let's just stick with this because this is important to hear just in terms of what this process is, just to get to a rulemaking session. So this whole process, if I heard this right yesterday from the attorney and now with yours, is the process of the state taking over enforcement of EPA regulations requires the state to say and to set rules that are the same.
They are just as protective as EPA's rules.
Right, and they could be more protective, but the EPA ruling, so there's little room for making them
Right.
lenient but I mean, the EPA up until this point had not been able to enforce the rules that it has in place on lead remediation. So essentially it was a federal law or federal rule and regulation that landowners, I'm not going to say they took advantage of it, but there was no enforcement over whether they did it or not. And so from a Department of Health's perspective, this was not acceptable any longer, that any of the processes that we've put in place for the last 45 years for lead remediation had stalled. I mean, I got that from the lead program, through VHCB, but the idea that lead remediation had stalled to the point where you felt, or the department felt, that it was necessary to take on the enforcement and certification essentially of this program. Is that fair?
That's fair. And I would say as important as the enforcement, or more important than the enforcement, is the communication and education about what was required. So we aren't looking to reform. We're not looking to enforce. We're looking to educate and communicate the law's requirements.
How do you reach out to all the landlords?
You talk to landlord associations, like
Who may not represent all the landlords.
Absolutely. We do the best we can. In a typical rulemaking, I might, if it's a rule affecting the practice of medicine, the department might reach out to the Board of Medical Practice, the Roman Medical Society, and the Hospital Association. It might be a phone call, it might be a week. In this case, we took a year and a half reaching out to as many people as we possibly could, whether they be individual landlords that we knew of who were large landlords, who owned many units, or in this case, associations. We went through the rulemaking process. There was additional, not to jump back into this, but to jump back into this. There was another public comment period. There was another public hearing. And at that point, we did something else that was unprecedented, which is we filed the final adopted rule and waited for a year and a half. Typically, we wait about 30 days before a rule comes into effect. We put it off for a year and a half to give maximum opportunity for us to communicate to everyone their obligations under the law. So that's sort of how we got here. I'll stop there. I'm happy to talk more about what was discussed yesterday, but I want to make sure I'm responsive to the committee's needs.
Well, again, given where you may sit, in your opinion, where you may sit from a legal standpoint about what you can and can't discuss, what we heard as a gist, if not the gist, is that there are three pots of people who are regulated. There's professional property managers and owners, so-called professional, and then there's property owners that own less properties plus homeowners, and then there's childcare centers, which obviously, given your introduction, having lead remediation in childcare centers is very important.
Yes.
And that there's a dispute over who should pay for certification and how, and that to me is where we are, is what we're talking about, is a dispute over who should pay for certification for this remediation. Is that?
So I think it's a question of whether you should be certified or whether you have to get a license. But to be clear that the requirement, the $300 5-year requirement was already in place under EPA's regulations. The three buckets I think are roughly true. That's an accurate depiction. From the department's perspective, if you are so you're talking about professional firms who do remediation, landowners, and childcares. Childcares were exempted. They only have to get certified. They don't have to be a firm because of frankly, the very precarious place on which childcare sit, in particular the time when these were passed. You may recall there was a contraction in the number of childcares available. In interactions with EPA, it was this point was discussed with EPA about landowners would be expected to be licensed. Their perspective was, if you, the landowner, are doing the work, you are a professional. You are being paid by your renters for the purposes of having a habitable home, and that you need to have the qualifications necessary to do that work, and that it is unlike let's say a childcare where the problem might be solved by putting in a plastic window well. This was discussed very briefly yesterday. If lead paint is not peeling and cracking, if it is not creating dust in the air, you don't need to do anything. You can take latex paint and you can paint over it. It's only when you are doing activities that disturb greater than 1 square foot that you're creating a hazard for anybody who might breathe that. It is the perspective of both EPA and the department that you need to have a very high level of qualification to do that work.
So it seems to me that the decision to create a separate category for childcare centers was a political decision rather than a scientific decision.
That's true.
And the question of where to put homeowners is also a political decision rather than a science-based decision. Is that correct from your perspective?
I think it's fair to say that those are yes-ish. Those are judgment calls. So those are just things that we discussed. So EPA was willing to live with, because of our situation, childcare owners. That, by the way, I'm not sure if it was clear yesterday. When we're talking about childcare owners doing the work, they don't mean they're not allowed to hire out the work themselves. They have to meet the exemption, they have to be the person doing the work. It is that person on the ladder doing the work themselves. And they, to be clear, they have to get the training. The contrast with landlords is, in the last few days, a landlord called and they said, I want to be doing this work themselves. And they misunderstood. They'd heard about this matter and they said that I would like to have that. And it was explained to them that they had 80 units. That landlord had 80 units. And that were they actually saying that they want to do all of the work themselves, it's in the rule, them or a blood relative. So you're right. It is a political decision, but made within the larger context of what's the likely outcome, right? And we did have to have those discussions with EPA. If EPA had said no, we would have said to Child Cares and DCF, we're sorry, we can't.
Right. And so, but the way the rule came down was a negotiation with EPA.
Yes.
If any changes are made, if this proposed change in H-184 is considered and passes through, do those negotiations have to be reopened?
Absolutely. EPA would have to approve, I shouldn't say that they have to approve, if any law was passed, they would review that and determine whether or not we will be withdrawn from the program. And if we made any rule changes pursuant to legislation or to a petition for that matter, EPA would have to approve all those changes.
And that won't take 30 days. Based on your previous testimony, EPA doesn't usually work that fast, but okay, boy, we can just keep going down into the wormholes here. Representative Parsons.
Thanks.
I do want to get to.
Of course.
I do want to get to Mr. Bierke, and we'll go till 10:30 on this.
Kind of in the same vein, completely different subject. I know in my line of work, we have to worry about asbestos remediation, and it's kind of the same thing. You can encapsulate it or you need to have somebody come abate it. How does that work in the same commercial, personal landlord? No.
You mean, is there in asbestos?
In asbestos.
Asbestos actually has a different set of rules, which I can't speak to at this moment. But there is not an exemption. There's not the same three buckets in asbestos. We've actually been looking at we need to rewrite our asbestos rules as well.
Okay.
But again, essentially the idea here is that, well, I'll ask Mr. Bierke will do his presentation to clarify what is that. So anything else for you right now?
I don't think so. I did send to the committee, which I think is am I now sharing there? No. There is a letter. So, and there is a letter that we sent to Mr. Bierke explaining the department's reason for declining the petition. That the committee now has that document, and you can review that at your leisure.
Yeah.
So if the committee were to say, yes, we want to address this and make it simpler for small landlords of 5 units or less, whatever it is, what is the time frame and what happens in between until that? What's the time frame for EPA to sign off and for that to become enabled?
Sure.
And what happens in the meantime?
Yeah, no, it's a terrific question. The answer is that I would literally call EPA and say, try and get through a phone tree to a human being, and then say, this is what's going on, what's our time frame? My expectations, our time frame would be, what they'll tell us probably is 180 days. That's both NRC and EPA tend to say, if you change a comma, we need 180 days. It can be anything between 60 days and 6 months. So that's what we would do. We would initiate a dialogue with EPA. But I can't speak to a time frame other than that.
And would that be, since this is a rule and we would be directing a change in the rule, would this be a whole new rulemaking process,
It would be. Well,
which is minimum 6 months?
yes, there's the real answer is that if you direct us through rulemaking, it would take 6 months. Not to go down this rabbit hole, but the General Assembly could say the department shall adopt this by emergency rulemaking, right, which would shorten the time frame.
So as of now the 18-month period, just to like put a punctuation on this. So as of now, all property owners have to be certificated,
Have to be licensed.
have to be licensed. All property owners have to be licensed.
If they are doing lead remediation work, they don't need to be licensed if they don't have an issue.
Correct. But that's even if they're doing their own lead remediation work.
That's correct.
And okay, I'll just leave it there. Representative Elder, sorry.
So they need to be licensed or hire a licensed contractor.
Sure.
Only if they want to do the work themselves, right? That's the big caveat is, are they disturbing lead paint? Are they engaged in lead disturbing behavior, actions? And
Representative Elder, did you?
I'm good, thanks, Founder Buzz.
Representative Parsons?
Just a quick one. If the unit's unoccupied, do they still?
it's really about whether or not you're disturbing the paint. Right? Like as a regulator, you're always looking for simplicity because simplicity leads to adherence.
Okay, I didn't know if nobody was in the unit, it would change.
Well, let me step back and have the caveat. If it's not being rented, that would be right. If it's no longer a rental property, if it's a rental property and somebody doesn't have to be occupying at the time, then the rule would still apply. Do you know what I mean? As opposed to like, we've abandoned this property.
Yeah, I know. Yeah, thanks.
And no, I think I'll stop there because we're not going to solve this morning, but enforcement then.
Yes.
You're saying that, we had this conversation over the last couple of years about health and safety in apartments. This is slightly different. This is what we've been talking about with health and safety in apartment buildings previous to this conversation is about flaking paint, not about remediation. We've allowed that to just be through a different committee or through the lead remediation program through the HCB. So, okay, education. If I own 80 units, and I just start, painting. I mean, obviously, if I'm going to hire out, I'm going to require a commercial painter is going to be required to be licensed, interior or exterior. But if I start painting the insides of my apartments one at a time or whatever, is it complaint-driven enforcement? Is it somebody just saying, oh, Tom's painting over, Tom's removing lead paint?
Yeah. So it's a great question. So it can be complaint driven. It's not exclusively complaint driven. It can be that frequently a renter will call us to let them know what's going on. Our inspectors, when we have a full complement of inspectors, go around and do random inspections of known properties where it's pre-78 housing. So it's both complaint driven and also we do, I don't want to say the word surveillance, but it's better than surveillance.
don't ask.
No, don't use the word surveillance.
You'll see an lead inspector just walk up to the building and start talking with folks who are on the building site and start talking about what's going on. The Department of Health does we do have the ability to enforce. We actually have finding authority. Just so folks here know, in all things related to the Department of Health, we actually have the legislative requirement that we seek voluntary compliance first, if at all possible. So typically what you see when there's an enforcement action is it's a very long process where we are trying to assist at every possible step in terms of education and communication and what they need to be doing. So fines are extraordinarily rare. It's fewer than a handful a year, even though there's hundreds of interactions with folks.
Okay. And the message here is not that because enforcement is lesser, that there's an excuse for not following the regulations. Okay. All right, thank you.
Thank you.
Appreciate the background.
Thank you.
Am I gonna?
And it,
Yeah, you're gonna have to,
I'm gonna let you just drive and I'm just gonna sit here.
okay. And we're all set.
Okay.
All right, next up is Alan Bjerke. Have I been mangling your names?
You do better than most. The easiest way is to think of it as beer key, like a beer and a key. Beer key.
Bjerke, not a church key.
I didn't look out with that name, no. Doop-a-doop-a-doop. I'm going to reduce this so I can see it. Okay, terrific. Hello.
Good morning.
Good morning. My name's Alan Bjerke. I live in Burlington. I've been a lawyer for about 27 years. In that arena, I mostly, from the very beginning to the very end, represented insurance companies in some regard, often dealing with policy disputes where there's a challenge as to which insurance policy covers what. And that arena comes up most in something called insurance subrogation. I'm one of probably less than a dozen certified insurance subrogation professionals in the state of Vermont. They're mostly not lawyers, they're mostly underwriters at insurance companies. I am a landlord. I have less than a dozen units in Burlington and Colchester. And I was a member of this esteemed house for 3 terms back in the 90s, just to give you a sense of who you're hearing from this morning. Oh, I'm sorry,
I'd say welcome back, I guess, but
can't take the pay cut today. Now that works. Okay. So when we're talking about rental housing that this bill affects, what are we talking about? It's basically pre-1978 properties that are being rented to others. But there are exceptions. So for example, if it's transient occupancy, such as a short-term rental, they're completely exempt. So where you're getting communications from people saying, if you make me do this, I'm going to turn my unit into a short-term rental, this is why. They would not be required to comply with the rules if they did that.
and why is that?
Because this is the statutory definition that the legislature intelligently. To put it in context, this is single-family homes. If you rent a single-family home or a condominium that you rent to somebody else, the interior of an ADU, accessory dwelling unit, is subject to this regulation, but not, and the entire exterior of the building, including the owner's section. Exact same thing with an owner-occupied duplex. The rental unit is subject to the rules. The exterior of the building is subject. And obviously, triplexes, quads, apartment buildings, et cetera. When we talk about constructed prior to 1978, we're talking about if the structure of the original structure was done prior to 1978. So if you had a house that was done in 1960, and then you added a wing to it to do a mother-in-law apartment, and then mother-in-law has moved on and you've turned that into a rental unit, that is subject to it, even if you put the rental unit on in 2023. So anything attached to a pre-78 building is included as a pre-78 building.
Sorry, just still rereading the first paragraph there. And so would something like an SRO, single room occupancy, shared bath, would that be exempt as if it were owner occupied?
That is a good question, to tell you the truth. I have 30 minutes.
Let's skip that question.
I will get back to you on that one. There was a good discussion about the history of lead control by David Englander before. I appreciate that. I would say that in 1978, lead was banned from most paint, certainly all consumer paint. They still have lead in paint on bridges and stuff like that, so don't put your tongue on a bridge. In 2010, the EPA adopted the regulations that Mr. Englander was talking about, regulating contractors, and those same regulations allow for the feds, the states to take over and preempt. We're going to look at those. In 2018, the legislature passed H 736, now Act 149, and that in doing so, the Department of Health came to the legislature and in the House and the Senate testified that they were going to treat professional contractors in one bucket and landlords and child cares in a different bucket. When they actually enacted the legislation, they put the landlords in with the contractors and childcare was separate. So this is the memo that Shayla Livingston from the Department of Health presented to the House and the Senate in 2018. And on the backside, you'll see these are the three groups of people. So you had property managers, and they said that if you have more than one employee, you need to become a RRPM firm, and you have to have licensed people on the job. If you're a pre-78 rental property owner, I'm just going to call those landlords. If you're a landlord or a child care facility operator, the rules were going to be exactly the same. Exactly the same. You're responsible for lead safe maintenance, and you have to be supervised by somebody who's taken the 8-hour lead safe course. They're so similar. If you look at the first sentence of what are the requirements for childcare facility operators, they forgot to replace the word rental property with childcare facility operators. So they were clearly intended to be treated exactly the same. So I appreciate that David and Representative Chestnut Hangerman did an excellent overview of LCAR and the process for administrative. So yes, when the administration adopts a regulation, they have to come back through LCAR. And as part of that, they give a economic analysis, impact analysis. And they also do some other requirements, who they reached out to, for example, and what comments they received back. And this is what the Department of Health told LCAR. They said that owners of pre-78 housing landlords will see very minimal change in cost because all these things exist today. If you're actually going to do this work, the cost is $50 a year. Insofar as everybody here is a small business, nobody's going to see a negative economic impact. What the Department of Health is now saying is that if you are what's called essential maintenance practice or inspection, repair, cleaning practices, those are the same group of people. We just changed the name in 2022 from EMPs to IRC. So I'll call them EMPs, but it's the same thing. You're allowed to inspect property. You're required to file an annual report with the Department of Health about your inspection. But now you're no longer able to actually do repairs of the surface in an apartment. So what are the real costs to a landlord? So there's that IRC EMP training that's $10. You have to take the 8-hour training course, which is between $250 and $300. The department is saying you can't just have a firm or a supervisor license. A landlord needs to obtain both. That's $300 for a 5-year firm license, $50 per year for the supervisor license. And you have to have specialty painting contractor insurance. And your regular policy of insurance that covers an apartment building will not cover this. And we're going to talk about that. Every 5 years, you need to take the course again, get redone again. Thankfully, the course after 5 years is just a 4-hour course. Non-compliance is $5,000 per violation per day. So the consequences of getting caught not doing this by the book is significant. So I said we're going to talk about insurance, so here we go. There are standardized insurance policies available in the marketplace. And for those that cover the small rental properties, you have these three. You have the ISO, which is the Insurance Service Offices prints these things. You have the ISO 3 and 5. Those cover single-family residences, accessory dwelling units, and owner-occupied duplexes. You have the HO 6, which covers individual condos. So one of my rentals is an individual condo. I don't own the whole building. This is not the master policy. This is for that particular one. And then you have the business owner's policy, or the BOP. And those cover non-owner occupied duplexes, apartments, quads, apartment buildings, et cetera. Then you have different policies that cover contractors. These are the ISO CGL. Commercial general liability insurance has an exclusion for professional services, but you can get an endorsement to be allowed to do that. So you would go to the insurance company and say, I want to be an electrician. I want to get a CGL policy with an endorsement to do electrical work, and they would give you that. And then there's straight up contractor insurance. You can't get endorsements for the ones that are in the top three, the HO and BOPs. And so those are just not available to you, and I'll show you what that is. So let's start with the HO5 policy. You have the policy, you have the liability coverage, then you have the exclusions or things that are not covered. You have the exclusion from personal liability and med payments to others, professional services. So bodily injury arising out of the rendering or failed to render a professional service. So what does this mean? This means that if you own your home and you're an electrician and you go to somebody's house and you do some electrical work and there's a fire and somebody gets injured, your homeowner's policy does not cover your liability as a licensed electrician. And probably the most common example that you folks are familiar with is the very first exclusion is motor vehicle liability. If you own your home and you own a car, you don't get an endorsement on your homeowner's policy to include your car. You buy a separate policy of car insurance. So the HO6, again, same thing, liability, exclusions, excluded from personal liability and med payments, professional services, the exact same language that you saw in the HO5. Apartment buildings are covered by the BOP policy. And here you can see this, these are all the ISO forms. That's what shows right on the bottom. Exclusions to liability, professional services. So what are professional services? There's two statutory definitions. They're both in Title 11. 11801 says any personal service to the public that requires a license. In 11817, professional service is a service that can only lawfully be rendered by a person who's licensed. We have a couple of cases. The first one is in Vermont, Maine Mutual versus Tinker and Fedor. Tinker was a licensed surveyor who did a land survey. And based on that, the owner of the property cut trees on land that wasn't actually his, because the survey was wrong. And the insurer for the surveyor, Tinker, brought a declaratory action to say, even if he's liable, we're not his insurer. And that was done under a business owner's insurance policy. There's the two types, Amex assurance, same thing for a plumber. So a plumber came to somebody's house, did work on their a gas pipe that caught fire, the whole building caught fire. And the court said that because he was a licensed plumber, the professional services exclusion excluded coverage under this is a homeowner policy, one of the HO policies. So,
Excuse me, so what this is saying, what those cases said is that if I hired, my house is insured by a particular insurance company,
yes,
and I hire a plumber or an electrician or a professional service person, and as a result of their work, my house burns down, that insurance company, provided it has this language in it, won't cover the loss.
no. You're covered if your house burns down. The electrician's insurance does not have to repay your insurance company under their homeowner policy. So Representative Odie did a stand-up job yesterday of describing the three groups of people and the two buckets that they fall into. Those two buckets are detailed here in 1752. So you have D, which is the uncompensated people, and it doesn't say childcare here, it says uncompensated, people that are doing it for no compensation. And then E is the compensated people, and those people have to be licensed. The first one, you have to take the training, D, you have to take the training and become certified. And that's the difference between a professional and a childcare.
Sorry, the training is similar. It's a matter of liability.
It's the exact same 8-hour RRPM training.
And this D, I pulled up Act 149 and I'd been focused on that paragraph anyway, so I'm glad you brought it up here. It says the commissioner shall, what this bill 184 is trying to do now is to say, can you have a certification or do you need a license for this group, right? That this would mean that you could operate as a landlord under a certificate instead of a license.
Correct.
And it seems the crux of why in this original bill you were not going to require full licensure was kind of on this lack of compensation, right? And that includes the landlords and that includes the childcare centers. They're doing this work themselves. Correct. Nobody's paying them to do it. So what I'm seeing here is that the commissioner shall certify, not license, right? So the verb here is certify. Of course, the last sentence that you don't have highlighted says, and met all requirements imposed by rule, yep. Right? And so clearly, the rules was back and forth with the EPA, and now this is part of the rules. This feels kind of like the crux of it because it's like the rule that came back is that you won't get certified, you'll get licensed. And so it's sort of like we turn this, the commissioner shall certify non-compensated individuals. Now they shall not certify them, they shall license them because of the rules. So it's sort of like the rule making has imposed something, i.e. licensure, that was really not part of D.
Well,
that feels kind of like a conflict because it's like the rule itself is making it so the commissioner shall not certify. Unless you consider licensing certifying.
Well, the statute makes the distinction between certification and licensing, so I'm following that rubric. But if you look at Shayla Livingston's memo to the legislature, that they said we're going to put treat landlords exactly the same way as childcares, which it doesn't say that, but that means they're in the uncompensated certification group. And then professionals have to be licensed, and they're putting them in that group.
I guess what I'm trying to say, this doesn't feel like it's true anymore, D. Like the commissioner's not certifying these individuals because of the rules that require them to get licensure.
The commissioner is saying that they now believe that landlords are compensated, doing it for compensation, because as has been said here, they're getting paid rent. Childcares are also getting paid money to.
But that's a fundamentally different service. I mean, getting rent for supplying a place to live and getting compensated for doing physical work are two different things.
I think there was an interchange here about well, let me pass on that. I think it's a political question. It is a political question about whether or not landlords providing rental property is a different kind of compensation than childcare's offering a place for children to go and have oversight.
Right. It's just if you had a rental property and you wanted to put on a new staircase, you could do that work yourself or you could hire somebody to do it. And if you hire somebody to do it, they're compensated. And if you do it yourself, you're not, in the sense that you're not going to necessarily say, hey, this month pay me an extra $1,000 rent because I put those stairs on.
Yeah, you would if you could.
Well, maybe that's the case, but you don't and you can't, you know. And so I think that it's just interesting because it does seem that this D that you have highlighted, to my way of seeing it, and I could be wrong, I'm wrong all the time, but it looks to me like this is kind of the crux of the issue. And it seems like what you're saying is that the deeming of landlords as compensated for their labor is really the dividing here, where we're saying childcare owners, they're not compensated because even though they collect money from parents to have their children there, we're dividing that from their labor when they are working on the space. Whereas with the landlords, we're saying we're not dividing it. It's all one. It's all compensation for the rental of the room.
I think it's very helpful that Mr. Englander posted the commissioner's response to our request that he have rulemaking, because what he basically says is we exempted childcare because there's a childcare crisis, and we don't think there's an affordable housing crisis, and that is.
And we'll read that on our own time. We haven't had.
Perfect. Thank you. So,
and I just want to. I think the other to your point about the compensation and how we can continue talking about this. I just want to give Mr. Bierke an opportunity to finish. But the idea of being a landlord is when you're accepting money for services, which is rent, you are also required to provide by statute and rule a healthy and safe apartment, which still doesn't get to the point that we're talking about here. I mean, it can, but I think the requirements are that it has to be healthy and safe, which means the lead remediation there has to be lead safety rules in place. The question is who's doing it.
yes. So, I'm sorry. RPM activities, this is basically disturbing a painted surface or as well as all of the enclosures and safety measures. As a condition of licensing, the applicant is required to have insurance in the not less than $300,000. So these are the regulations. There's about 109 pages to them. And in the regulations, this is where it clarifies there's two sentences in 7.1. One is target housing, which is any housing, owner occupied or not, which is built prior to 78. And the second sentence is the childcare and rental properties. And there you see you can't disturb more than 1 foot inside, 1 foot outside. So in order to get a license, you're required to have a license or a certification. The license, 6.3, requires this insurance. And so the insurance here in the yellow you'll see is insurance that will indemnify properly a person who suffers damage from lead paint activities or activities. So this is not the presence of lead on a property. This is doing the act of disturbing more than 1 square foot. By comparison, the childcare certification does not require insurance. It requires that they pledge that they will not offer their services to anybody else. And number 2, they have to tell the department which properties they own, and they're allowed to work on those properties. If you're caught working on another property, you would get your certificate yanked and couldn't even work on that property. Yes.
So the insurance is for you as a property owner?
Well, in this case, it's for the licensee, the person who is trying to become licensed. So a licensed person has to have this insurance. We already have.
Is it a separate category of insurance from what otherwise? So the insurance is for the licensure, right? It's a requirement of a licensure.
Correct.
So but that is for normally, I guess what I'm wondering is it easy for landlords to get that kind of insurance?
It is impossible. We'll talk about that.
Okay.
So what is the upshot? The upshot is the new regulation has an insurance problem. Rental properties are covered by specific HO and BOP policies. These policies exclude coverage for professional services. Professional services are those activities that require a license to perform them. The regulations require landlords to become licensed to paint their own property. This licensure requirement cancels the insurance liability protection of the HO and the BOP policies.
That's what I was just asking.
That's how I said we'd get to it. And small landlords cannot get professional contractor insurance. I've been working with my agent for months, not able to get it. And it's not just me. You have in the comments that have been submitted today, I would take a look at a letter from Paul Leclerc here in Montpelier. I've never met this man, but he includes the entire trail of his conversation with his agent at Hickok and Boardman. And the ultimate result is, I can't get it for you. You're going to have to hire somebody that's licensed. So why not just hire somebody that's licensed? Well, there aren't enough of them. As of January 1st, there was only 35 licensed contractors for the entire state, only 7 for all of Chittenden County, 2 for Addison County, 2 for Franklin County, nobody in Grand Isle, Windsor, or Orange counties. There's only 1 in Washington County, Capstone Community Action, and they don't hold their services out to private landlords. 1 of the 2 in Addison County is Middlebury College. They won't go to work for a private landlord either. Now, I will say that January 1st number is just because this is the presentation I've been given for a while now. The last time I checked, it's up to about 70. They're not gonna get to 250 by this summer. You're talking about 66,000 rental properties in the category of pre-78 rental property. There's just not enough people out there and to do this work. And the department rolled out the penalty before the ability to comply exists. So as the commissioner's letter that Mr. Englander put into your record said, the Department of Health thinks that if they were to treat landlords the same as childcares or exempt, nobody's asking for exemption, but exemption from the licensure requirement, that the EPA would not approve them. And so we looked at the states where the EPA has approved. We were the 14th state. So there's 14 of them out there. This is Georgia. In Georgia, the rules don't apply to people who are doing work in residential dwellings, apartments, when it's unoccupied. So in Georgia, you can you can paint a surface in an apartment between tenants, which is when most painting happens. And this is Iowa. Same outcome, same thing. These are regulations that the EPA has approved for a state to take over the EPA regs, and it has this same exemption for landlords. Oklahoma, exact same language as Georgia, exact same language. Utah, exact same thing. Now, this is a bigger hole than what we're suggesting, because these people, a landlord who's painting in between tenants in these states, don't even need the 8-hour training. They don't need any training at all. Same thing with Washington State. So what Mr. England and I are talking about is the EPA regulation. It's 40 CFR 745 subpart Q, is I think. And it's separate from the, license, the certification of professionals. This is for a state to have their regs take over. And these are the requirements. You have to have a training program. You have to have a procedure for the certification of individuals or firms. Vermont is requiring that we get a firm and a supervisor license. The EPA only requires one or the other. And the painting work, it's really not the painting, and I want to dispel that. You could just paint over this wall and this trim without this license. But your paint is not going to stick to that semi-gloss trim unless you disturb the surface. It'll peel off within a couple of years. So, and if you just throw paint on a wall without patching and sanding it and getting it prepared, you can just get a really crappy paint job. So we don't think that is what Vermont tenants should really be able to expect. But what you'll not see here is a requirement that someone be licensed, and you'll not see a requirement that somebody have insurance. Vermont is unique. We're the only state that mandates this insurance as part of the licensure or certification. So this is the H-184, and as you went through yesterday, what it does is it takes that bucket, which is paragraph D, and says owners of rental housing on their own property would be eligible for certification. So in the example that Mr. Englander gave, if you had 8 units, I have 12. I'm exhausted. I can't imagine that a 80-unit operator would actually do the work himself. If you have an employee, that employee is not working on their own property. They're working on the boss's property, and they do need to be certified. So you do have a natural limitation here of how many properties are you going to want to actually maintain yourself. So in conclusion, the Department of Health didn't do what they told the legislature they were going to do. If the EPA told them they couldn't do that, they should have come back through the legislature and gotten authorization to do that. The presentation to LCAR misrepresented the economic impact. There are not enough, I'm sorry. The new regulation has an insurance problem that prevents landlords from becoming licensed to work on their own properties. There's not enough licensed painters to do the work. And the EPA has approved several other states that allow landlords to paint their own rental units without licenses or special insurance. Under H-184, a landlord would still have to get the full 8-hour training, pass a written exam, use the lead-safe work practices and equipment. This is basically special expensive HEPA vacuum cleaners is the number one thing, and not hold themselves out for hire to others. So we ask you that you pass the contents of H-184 this year. Obviously, I know that it did not make crossover, but it's a couple sentences that could be added to, I don't know, S-100 is something called an omnibus housing bill coming to you. Seems like it'd be germane to something called omnibus. And one of the things that I thank Mr. Englander for going through and Mr. Chestnut Tangerman, there is a legislative intent thing here. It is important whenever you're asking the administration to adopt a regulation or amend a regulation, that you include this statement of legislative intent. Because it is the vehicle that allows LCAR to say, we're going to object to this rule. And as was explained to you, once there's an objection from LCAR, the burden is on the state to enforce the rule and show that it was legitimate. The administration agencies don't want that. They'll go back and amend it if that is the case. So I know that your ledge counsel said, oh, it's here to help you understand what's going on with the bill. Actually, I think there's a provision in Title II that says that you should put a statement of intent in when you are anticipating that the result of legislation will be a regulation. So I'm out of time. I have a couple of things that I would like to respond to what Mr. Englander said, but it's your agenda,
I'd like to stop right here, but we have to start hearing testimony on the bill that's on the floor today, on amendments. So, but
I'm available to come back.
yes, and I think if we take this up further, we will require further testimony as well. So mark those notes, pin them, wherever you want to put them, and then we'll respond. You can send it in a note to us if you'd like, and we'll post it.
I'll wait and see if it goes further.
All right, but thank you so much for your time, for coming in. I know you've been working hard on this, and then we'll read Mr. Englander's note that was posted, and we know it's not a simple bill. The solution, any one-line solution seems a lot simpler than it really is. As I'm sure you remember, there's no such thing. But we'll be addressing this, I'm sure, throughout the course of the session.
Thank you very much.
Thank you. Yes, we're going to stay put, and then we're going to take a break after we hear from Representative Shy from Appropriations. Because we'll need a break in order to hear the amendment from the others.
Yeah.
I went to the wrong committee room first. You all keep moving around, it's harder to hit a moving target, so.
Yeah, that's it. Yes, we're no longer in the attic, we're no longer on the third floor, we're here at the
Anyway.
intersection of noise and what? Noise
And commotion. We have some of that downstairs too, when all
Oh,
the
my
school
goodness.
groups come in. If we don't keep our door shut, even when shut.
I would think that being down in that hallway is very difficult.
It's interesting.
So,
It's another conversation.
Representative Shy, do you know all of us? Have you met all of us at some point?
No, I don't know everybody.
Then we're gonna go around the circle very quickly. Representative Stevens from the Washington Chittenden District.
Claudia Lamont, Morristown, Elmore, Worcester, Woodbury, and the northern part of Stowe.
Welcome.
Joe Parsons, Newbury, Topsom, and Groton.
Ashley Bartley, Fairfax, Georgia.
Welcome. I recognize who's new.
Elder Starksboro, good to see you, Robin.
Nice to see you.
Hi, Elizabeth Burrows, Heartland, West Windsor, and Windsor.
Hi.
Morning, Larry Lieber, Essex, Orleans, District 1.
Great.
Mary Howard from Rutland City,
Yeah.
District 6.
The other Robin.
Yes.
That's what we call each other,
The other Robin. If it was 2 years when you weren't here, I had to be the one to answer all the time. It was very lonely. When they said Robin, it always meant me, which was not always what I wanted, but anyway.
There are a few Batmans.
I live in a bat cave downstairs. That's what I call our room, so yeah. Anyway, so Representative Robin Shy from House Appropriations, here to tell you about our amendment for H66.
Microphone is yours.
Okay, first, thank you all for the work you have done to put together the bill. Ways and Means did just a lot of work to get this together, and it's exciting to be back in the saddle again on this bill, so I'm excited about that. We have an amendment that has 5 instances of amendment, and hopefully you'll have a copy of it. I'll just tell you now, the 4th and 5th instances of amendment are technical corrections that we were asked by Ways and Means to put in with some date changes. So the substance of ours is the first 3 amendments on our bill. I'm using the paper copy that was I think it was the version out of Ways and Means that was 66 pages. But the first instance of amendment is in section 13, appropriately named appropriations. When this bill left Ways and Means, there were 3 appropriations totaling about $111.5 million. Oh, look at that. And some money went to establish the family or the medical leave insurance fund. Some money went in there. Some money went to the tax department, and some money went for other costs of operating the program. So they had 3 different appropriations. We're grateful for the roadmap that was developed and the timeline, and part of the fiscal note, which I'm sure you have, showed exactly who needed what in what years. So we decided to divide 111.5 by 3, more or less, and we have a single appropriation of $37 million. So that's section 13A. And so rather than appropriate the 111.5 million, we are appropriating 37 million, or about a third of the cost, to the Division of Family and Medical Leave just for FY24 to establish the Family and Medical Leave Insurance Program. So that is now the only appropriation in the bill. So the tax department doesn't need funding. They have told us until fiscal year 25. So we're not appropriating any money to that. That would happen in fiscal year 25. And the reserves can be built up over time. We're giving more money than is needed in the first year, but we're trying to smooth out the costs of ramping up for the program. So we picked 37 million to do it for this year.
So with respect to that comment, what represents the treasurer's estimated cost? I don't have a JFO note up. They're over a 2-year period. I'm sorry, they're over the 2-year period. They're expecting to spend $30 million.
Over the 2-year period, the Treasury Department, which is where this would be housed, is expecting to spend about 24 million. And then in FY25, tax department is about 4.2 million. So over those 2 years, it's 24.5 plus 3.8. So, around 29 million in the first 2 years. So we've covered more than what is even needed in the first 2 years.
And so essentially those are, that extra money is going into what would be considered the reserve fund?
All we have done and said is to use to establish the Family and Medical Leave Insurance Program.
Okay, thank you.
So we tried to keep that way.
Yep.
And that's a little different than what Ways and Means did. They had more of a specifically pre-funding the reserve fund element to the appropriations that left their committee. Is that right? Those were some of the big chunks.
Had, yes, the special fund for costs of operating, so 58.5 million. They put the whole amount of everything into 1 year.
Okay.
So were giving 46 million to the Division of Family and Medical Leave to cover all 3 years to develop the program, do the IT, hire all the positions. That was the 46 million. The tax department was getting 6.5 million to cover their IT, their positions, whatever else they needed, although they didn't need the money until FY25. And then the 58.8 million was to go into the insurance special fund for the cost of operating the program during the calendar year 26 and maintain the reserve requirement.
And so it's that last category that we don't see in this because we've got programs set up.
You could use some of it for that.
Operation. You could,
right? I mean, they could choose
to use it for that.
I'm looking at Damien.
Yeah. So for the record, Damien Leonard, Legislative Counsel. So the 37 million here, it's going into the special fund. For the first year, it's being appropriated to Division of Family and Medical Leave. What's unspent will be carried forward and appropriation. So that special fund can be used by both tax and the division, but each year our appropriations committee basically says how the funds in it need to be spent. So for FY25, what this allows the appropriations committee to do is come back and say, you have a better idea of what your expenses are. Tell us what you need. Here's what we'll do with carry forward. Here's what we'll do with new money, and figure out how to fund it, and then do that for 25. Same thing for 26. Maybe tax receipts come in higher or lower than estimated. Maybe the reserve fund is adjusted because of better modeling as time goes on. And so they'll be able to fine tune with each year rather than preloading 3 years with an inflation factor, trying to figure out what the economy is going to do, where the IT contracts are going to come in and so forth. So this is basically, they're trying to smooth out the estimate. So we're paying it out 1 year at a time. But it's also, so right now, the only part of the program that needs the money is the division for starting the setup. What they don't spend this year will just get carried forward and reappropriated next year.
And it's appropriated to the division, and so we've got the special fund, which you explained very well, and then we've got the reserve fund that we'll start to get. But
The reserve is in the special fund.
the reserve's in the special fund.
yeah.
It's all one fund.
Right.
All one
I think
fund.
that's the clarification I was looking for.
Yeah.
Okay,
Okay, thank you.
that's good for me to know too,
Yeah,
so
yeah,
thank
yeah.
you. Okay, so that's the first instance of amendment. And the second instance of amendment strikes out section 14, which is the positions for the Department of Taxes. And I'm looking at too many things here.
Those were 15 positions.
Right, the 15 positions that were in the Department of Taxes. So we strike out that section and we insert a new section that says deleted. So we delete that section. That's the effect of the second
And
amendment.
those were FY25 positions.
Right, so that's why we don't need them for now. They were very clear. Tax is very clear. This, if you don't have this fiscal note, I really strongly recommend.
Yeah, we have it.
So it shows for every year for tax and for treasury what they need. It's been a wonderful roadmap to help all of us, because now we'll have this for future years as well.
But what I'm hearing from appropriations,
Yep,
as a rule, we prefer to address expenditures 1 year at a time.
yes,
And so when you say roadmap, at least that's something that you'll keep in a file.
exactly,
And next year, the department will do their work anyway.
right,
And they'll say, we don't need this much, we need more, whatever,
Right.
whatever the case may be. But in essence, we had another bill earlier this year where it asked for a 4-year appropriation.
Right.
And that's just something that in general
it's a practice we don't do.
do until
Right.
something's quote unquote baked into the budget.
Yeah.
And then there's an expectation that'll be funded
Right.
at a particular
Right.
level.
We may do something for a couple of years within a biennium, but as a rule, this body doesn't also tie the hands of future legislatures. So this goes across 3 fiscal years, so it goes across 2 legislatures, the way it was designed. So, and as others have said, we can fine tune over the year. We expect there will be some carry forward. But if there's 37 million and there's a need that this timeline gets bumped up and there's more money, there's money there in case we need that for next fiscal year. So we're not under-resourcing it either. I'm trying to be responsible.
Thank you.
Okay, so that second instance strikes out section 14 in the Department of Taxes positions. The third instance of amendment is kind of like a strike all. We strike out section 15 entirely, but then we put back in essentially 15A, which is the 9 positions that the Division of Family Medical Leave needs in fiscal 24. So the original bill had, here's what we need in 24, 25, and 26. We said, we're going to fund 24 from the 37 million. So we did not authorize the other positions in future years at this point. So there's 6 positions that are permanent classified and 3 that are permanent exempt.
And just for our edification, a classified employee is, an exempt employee is someone appointed by the
I'm going
treasurer.
to I'm going to phone a friend to Damien. I don't know.
Sure, so,
Just for I just want to so
Yeah.
that we're clarify when we introduce, I'd like to just hear what the definitions are.
yeah, so exempt employees, the easiest way to think of it as you're exempt from collective bargaining. So exempt employees are appointed by whoever the appointing authority is, in this case, the treasurer or the director. They don't have contractual job protections like classified employees would if they're part of a bargaining unit. So exempt employees are typically people in either a policymaking or senior managerial position, or in what we call a confidential position, meaning legal counsel or someone who is an advisor who's going to have access to sort of the top level of policymaking, which would be inappropriate to place within the union because of the potential conflict when you get to collective bargaining negotiations if someone is also privy to the inner workings of management. So that's the exempt employees. So it's typically you're within a standard agency. It's your agency head, your legal counsel, and some senior policy folks.
Thank you.
So that means classified are part of the collective bargaining.
They potentially.
Okay.
Potentially think of classified employees as your sort of rank and file employees,
Yeah.
not to minimize the work they do, which is very important, but just they're not in that senior leadership where you can be fired by your boss because they're not happy with the way the department is running. A classified employee has more job protections and so forth.
So the exempt people are serving at the pleasure of.
Right, they're all serving at the pleasure of the treasurer. If the treasurer determines that they're unhappy with the way the division is running, they could fire the whole leadership team and replace it if they wanted to.
Right.
Okay. So that is the third instance of amendment. So that's really the appropriations. We did a third of the cost. We eliminated the positions for tax and we only included the positions for the Family and Medical Leave Division that are needed in FY24. That's really the appropriations, 3 amendments. The other 2 amendments are in section 12, and they are related to private plans. And this was what House Ways and Means asked us to do. These are really technical corrections with date things to make it consistent with the rest of the bill. And so this relates to private plans. In initial approval under 12A, it says an employer wishing to utilize a private plan. It started, the language that was in there was beginning on January 1st. Well, they aren't actually going to begin then, but it says for calendar year 2026. So we're just changing that date.
Right, these are technical changes because they shifted the start date from an earlier draft in House Ways and Means would have started benefits on January 1. They then moved it out to July 1 to allow more time to build up the reserve. And in making the change, I missed 2 date changes in the private plans. So by switching from beginning on January 1 to for calendar year, we reflect that the private plans will be exempt from the taxes for the calendar year, but won't have to start paying benefits till July 1. And so that's why I had to switch from a date certain to for calendar year, because there are different dates. And then the change here from January to July reflects the benefit start, which moved out to July. So this is protecting the private plans from having to do something that other employers wouldn't be subject to.
Okay.
And that's it.
Representative Parsons.
I have a question does that change I can't figure out how to word this. I had asked for a change for private plans because they wouldn't, they'd have to start paying before they can actually get approved to not.
Right. So
keep that with the changes.
So yeah, the tax exemption for private plans that you had asked for in this committee added is kept with that language.
Perfect.
The big difference is this committee had passed it out with benefits having to start on or before October 1. It moved up 3 months in the House Ways and Means to July 1.
Thank you.
Okay,
Questions?
any other questions for what they did?
I can understand the whole not tying future legislature. Absolutely. It really seems like the big portion of it is trying to reduce the sticker shock to me when I see it. We're saying that this program costs $37 million.
Well, I think the fiscal note is gonna stay as the fiscal note, so people will know what the full cost is and what's there. But we can only appropriate what we want to appropriate in 1 year.
I know, I'm just thinking that maybe your constituents read more into the fiscal notes than mine, but when they see this and think that it's a $37 million program, followed by a $37 million program, followed by another $37 million program. And I just have concerns that we may have the money to do it this year, but if 2 years from now, we're struggling and we have half of a program that's unusable because we can't find the other money.
Okay. So we got further clarification from the clerk this morning about, in this ongoing conversation about straw polls and whatnot, and basically, we will take a straw poll on this now. We will also take a straw poll on the amendment that's coming up after this. Ron got mixed messages. What we got from the clerk this morning was that we'll take a straw poll and it'll be a show of hands, basically. I'll stick to the show of hands right now until we find some quality time to put an hour on our schedule and discuss and really set a policy with some of the concerns that were raised on voting in general, just so that when I say straw poll, you'll know until different that it'll just be the show of hands. So all of those, so that what's on the table is this amendment. And all of those who are in favor of this amendment, please raise your hand. 1, 2, 3, 4, 5, 6. All opposed? 3. So we have 633. You have that?
Yes.
633 on this amendment. Thank you.
Thank you.
See you out on the floor at some point this afternoon.
Whenever there's a roll call, otherwise we'll be busily doing our budget.
It must feel so good to not have to go to the floor and just keep working all the time, huh?
We just keep working and working, yeah.
Yeah. All right.
They all
Thank you, Representative.
Thank you.
All right.
Thank you, Dave.